With the first case, Glenda McKinney-Oppenheim versus State of Florida.
Please, honorable court, opposing counsel, distinguished members of the bench. My name is David Kirsch. I represented the defendant, Glenda McKinney-Oppenheim, below and on this appeal as well. And I would like to reserve approximately 3 minutes for rebuttal.
Okay, let me make sure this is...
It is working here, sir.
Okay.
I could reserve 3 minutes for rebuttal.
Okay, go ahead.
Ms. McKinney-Oppenheim was charged with solicitation to commit first-degree murder below. She testified in her defense and claimed that she acted in self-defense and presented evidence of the battered wife syndrome. I think the briefs are rather as thoroughly as complete as possible relative to the facts given the limited space available. There was certainly evidence of violence throughout the marriage. It was corroborated by independent witnesses, family members. The testimony of the state's doctor in rebuttal, Dr. Jeffrey Danzinger, he said if you accept the testimony of the defendant, then the acts of the husband were cruel, brutal, sadistic, and so her credibility became the focus of the trial when she took a stand in her case in chief, and then of course the state had the rebuttal argument. The issues presented here are one of evidence and one of admissibility of character evidence specifically in the form of opinion testimony and prior specific bad acts. It's the defendant's position, the appellant's position, that her state of mind was what was at issue in this trial. This was a case of self-defense, and her state of mind, her reasonable belief of imminent bodily harm either to herself or her 10-year-old daughter, Ashley Oppenheim, the biological father of the parties. That was what was at issue. The state's position is that her character was put into issue by admission of testimony relative to the battered wife syndrome. I don't believe that her character was put at issue. The two controlling, I believe, rules of evidence here are 9404, when character evidence is admissible, and 9405, how to prove character if in fact it is admissible. It's our position that we did not place her character in issue, and when the biological daughters of the defendant testified in the case for the state's rebuttal case against her and offered testimony, which I believe was opinion testimony, when they testified that she was manipulative, she was aggressive, she was mean and horrible, that she treated me that way in her childhood, the specific bad acts.
Why wouldn't the testimony that she was aggressive, and that I think there was also some testimony that she was aggressive towards her spouse, why wouldn't that be evidence that the jury should consider in determining whether this woman suffered from this particular syndrome?
I believe that the testimony that she was mean and aggressive, manipulative, was opinion testimony, Your Honor. And opinion testimony is not admissible to prove any type of character evidence. It should come in the form of reputation under...
Wasn't this testimony elicited from a witness that actually saw, these events happen and informed the opinion that she was mean and aggressive, and that there were actually incidents where she was the aggressor against her husband? Is that part of the evidence or not?
This was first-hand knowledge, correct.
Okay, and so you're saying that although that may be relevant, it's inadmissible because it's opinion testimony?
Well, I don't think it is exactly, Your Honor. What I thought was relevant for the children to testify to, and these were the children who lived in the home during the marriage, was the violence between mom and dad, or the lack of violence between mom and dad, certainly who started the violence, who the aggressor oftentimes was, and what she saw. But for her to give her opinion that mom was, I think her testimony was, you don't understand, mom was an aggressive and manipulative person. She treated me mean and horrible throughout my childhood. She took me to an orphanage to give me away. She gave away my favorite childhood dog as punishment to me. And the last time I saw her, she was marching around her property with a gun, threatening to kill anybody who came on the property. That testimony, that body of evidence had nothing to do, absolutely nothing to do, with the issues presented in this trial. It was inflammatory, prejudicial, and certainly misled this jury. Coming from her own daughters, that testimony had great weight. And the way the case became structured in the trial was when the state's doctor testified, if you accept the testimony of the defendant, she is post-traumatic stress disorder, she is certainly a battered spouse, and if she reasonably feared for the safety of her daughter, Ashley, then an expanded notion of self-defense would apply. So her credibility became the issue. And then when the state, or when the trial court allowed the state to enter this character evidence, it just destroyed her credibility.
Mr. Kears, let me ask you, it seems to me that we're lumping an awful lot of things together. And let me ask you to, let's break it down into smaller bits. We've got the daughters testifying Mom is mean, manipulative, and aggressive. Now, let's just look at that testimony for a minute. Mom's testimony and the testimony of Mom's witnesses, as I understand it, and the experts, was that Mom is very passive. She's been beaten up. She's been the victim of spousal abuse over years. And, you know, this idea that she would hire someone to kill her husband is really extraordinary. Why isn't that sort of testimony proper rebuttal to the idea that Mom is this really passive, Miss Milquetoast kind of character? Just the general saying, my mom is an aggressive, manipulative person.
Well, to me, that would be opinion testimony inadmissible. If we're going to talk about that, I think it should be in the form of reputation of her character. But precisely, Your Honor, there was not testimony that she was this milquetoast, passive kind of woman. Those are the characteristics of a battered spouse generally. But Dr. Greer's testimony, he testified in the defense's case in chief, was that pursuant to the MMPI, her characteristics were that of paranoia, anxiety, and anger. And he never testified that she was, you know, a passive and dependent person, although that helps to explain the battered spouse as a general idea. But there was never testimony that she was, in fact, passive or dependent or helpless. She was, given the husband's disability, she was really the bread earner of the family. She was the one that was working and providing the means of support. But because of his disability, and he admitted so himself, he had issues of anger control, and he would just, as described by some of the witnesses, go into a rage of anger and break furniture, and you know, there was testimony of the violence between the two of them. So, I mean, to have the daughters testify as to their opinions, that was purely an opinion, that she was mean and aggressive. Quite honestly, members of the court, that testimony just led you to believe, you know, I didn't even like her as I sat next to her and heard that stuff. I mean, and that's what happened to the jury. They said, you know what, I don't even like her. If that's the way she is, I don't even like her, and therefore I can't believe her.
Well, you know, in fairness, and you know, I do have some problems with some of the testimony that the court admitted as it related to, you know, taking her to the orphanage and giving away her dog and that sort of thing. But in fairness to the state's case, don't you think, I've read the transcripts of the two tape-recorded conversations between the intermediary and between the alleged hitman. I mean, those are pretty damning. I mean, even if she had been, you know, Mother Teresa, I think if a jury heard those statements come from her, you know, they're pretty damning statements.
They are, Your Honor, and we never contested the idea that we tried to hire someone to kill him, but we did it because she was in fear, reasonable fear, that he was going to harm her child. He'd already, you know, he admitted he had made some very cruel statements to the child. He had hit the child. He had stepped on her and told her, I don't love you. And he would tell her that, and you know, that was what the case was about. And in those statements that you bring up, the very first one with the intermediary that was intercepted by the Port Orange Police Department, he said something like, well, you can have him killed and you'll get your money, your policy money. And she says, well, yeah, but we'll be safe. We'll all be safe. But that was resonating in that first.
There's no question. I read the transcripts. There's no question that, you know, she emphasizes a number of times that she thinks that this is the only way that she can assure her safety and that of her daughter. And there's also no question that she's trying to hire this guy to kill her husband. And I guess the question in my mind, and I'm going to pose this to the state, is even if we accept the idea that the testimony that you're contending was error, in the scope of the case. I mean, the jury heard all sorts of stuff about what a bad fellow Mr. Oppenheim is, and as a result of, I guess, falling off a building and hitting his head and that sort of thing. You know, I mean, the real question in my mind is, even if we accept this as error, is it harmless error?
Judge, Your Honor, with all due respect, it is not harmless error because of the dynamics of how that trial proceeded and how it came to be that, you know, the state's doctor, if you believe her, then, you know, essentially you're right. She's a battered spouse, post-traumatic stress, and an expanded notion of self-defense will apply. He put her credibility at issue. Then to allow the daughters to come in there and do character assassination, that's the unfairness, and that's where the trial, she was denied her right to a fair trial. And it's not harmless error. I think the burden of proof would be on the state to show that the evidence, the error, did not have any probability of contributing to the verdict. And it's just what we're talking about is just a small body of evidence within a 7-day trial. However, because of the way the case was postured, with the doctor's testimony for the state, if you believe her, I mean, he had a dichotomous opinion. If you believe her, essentially she wins. If you don't, she's malingering and avoiding prosecution. And so the question squarely for the jury was, okay, do I accept the testimony? Because 80% of the testimony regarding the violence in the marriage came from the defendant herself. However, it was corroborated by Dagny Tremblay, Thomas McKinney Jr., Ashley Oppenheim herself, and the defendant. He did not admit, or he did not deny, that some of the things that were testified to about the dead dog in the truck, he admitted the dog was shot out there, but he didn't do it. The dog in the truck was an accident. He admitted the fight. Well, he admitted a lot.
There's no question that he's not a very likable fellow. I mean, the testimony is pretty clear on that.
But that evidence that was admitted about that, Your Honor, was not to make him out to be a bad fellow. That evidence was admitted to show the state of mind of Mrs. Oppenheim. And to do that, you have to put out all the violence that occurred before them. And that creates her state of mind. Yes, sir.
3 minutes left.
Thank you. I would like to reserve.
Thank you.
Good morning. May it please the Court. My name is Allison Morris, and I represent the state of Florida in this matter. This is a solicitation to commit murder case. The defendant's defense was an expanded concept of self-defense, that being the battered spouse syndrome. She produced an abundant amount of evidence setting forth the fact that she felt that she had no reasonable fear but to solicit the murder of her husband. She had no reasonable way out. The state was completely, in fact, obligated to rebut that evidence.
Was it error to allow one of the daughters to testify about how her mother had mistreated her as a child by taking away her dog? Or?
No, I don't think that was an error at all, because it showed that she did not change throughout her marriage. She was always this person who was a very aggressive, confident person.
How does that go to the issue of self-defense?
Because the battered spouse syndrome develops over a large period of time, and she was trying to show that through all these years of being abused, she felt she had no reasonable alternative than to do this.
Well, can you be a good mother and be a victim of spouse abuse?
Certainly you can.
And can you be a bad mother and be a victim of spouse abuse?
You certainly can.
So how is that relevant then to?
Well, it also had to do with her fear of protecting her daughter. She said that the husband was the one who was abusing her daughter, but then you also had the testimony that she did not necessarily have this fear for her daughter coming along. And certainly any error is harmless error in light of the overwhelming evidence of guilt, in light of I think this goes to your question, Judge Orfinger, in light of the two recorded transcripts that the jury heard, in light of the evidence, the body of evidence induced at trial, and in light of the letters that the daughters had sent to them.
What provision of the evidence code makes? Let's talk about some specific testimony by the daughters. The testimony that I think troubles me the most, and I don't remember which of the daughters, but one of them says, Mom took me to an orphanage. Mm-hmm. Mom gave away my favorite dog. Mm-hmm. and Mom was marching around the property waving a gun around. So
Well,
tell me what provision of the evidence code makes that admissible testimony?
I believe that would be the specific act. Those are specific instances that go to show the mother whether she was a person who would develop this reasonable fear of the defendant, especially since she put this all into evidence. As for marching around the property, I believe that was something she brought up about whether she was really scared of the defendant or not, whether the whether the victim was going to come out to the Pearson property with a gun and shoot her. I think that testimony went with that.
The statute that you're speaking of says when a character or trait of a person is an essential element of a charge, claim, or defense, proof may be made of specific instances of that person's conduct.
Mm-hmm.
So help me understand, let's parse it down finally, and let's talk about Mama took me to the orphanage and said, I was a bad girl and she was getting rid of me, basically.
Mm-hmm.
What trait or character issue is relevant to the prosecution that we're talking about, that Mama threatened her daughter is dumping her at an orphanage?
I think it goes to show the overall personality of this woman. It's not a woman who, as being a dominant force. It's not a woman who is likely to suffer from battered spouse syndrome.
Well, but aren't you confusing reputation testimony with specific instances of conduct?
I think that goes to
And if you wanted somebody to come in and say, that's why I don't have a terribly difficult time, although it wasn't artfully done,
Mm-hmm.
I'm not nearly as concerned about the testimony about Mama's aggressive, manipulative, and just not nice. That it wasn't very artful, but that strikes me more perhaps of reputation.
Mm-hmm.
But the specific acts of conduct are different. Mama tried to dump me at an orphanage.
I think she put her character at issue when she started asserting this battered spouse syndrome, and I think that was part of reflecting on her character. That character in turn goes to create the state of mind of this woman and whether battered spouse syndrome applies in this case or not.
So if Miss McKinney-Oppenheim had kicked a dog 30 years earlier, or taken $5 from the collection plate at church, that all goes to the issue of whether she could be a battered spouse?
No, but it gets more and more remote when you do that. She was putting forth this testimony of her concern of her daughter, and I think that this came in to show her concern of her daughter and Ashley, and it also went to show her relationship with her children over the years. And she put self-defense into issue. She put her character as being a person who is going to have this type of reaction into issue, and the state was entitled to rebut that. I think that was part of the big picture. The question is, would a reasonable person in her circumstances feel entitled to use the self-defense? I think this goes to show the whole circumstance of the picture. Beyond that, and like I said, I think if there's any error, I believe it was harmless error in light of the other evidence that I presented, and I think I discussed that in my brief. Beyond that, if no one else has any questions, I will rely on my brief. Any other questions? I would ask this court to affirm the conviction and the judgment. Thank you very much.
Thank you.
Judge Orfinger, I think you hit it right on the head with the specific acts of this prior specific bad acts. In order for that to be admissible, prior specific bad acts, the character has to be an essential element of the claim or defense, and Earhart gives several issues of when that is. The most clearly is defamation, where truth would be a defense. He talks about negligent entrustment. You would have to show, prior bad acts of the individual to whom you were entrusting the vehicle to, and for the instances of specific bad conduct that came up, those had happened more than 10 years.
Mr. Christian,
from what the relevant time frame was in this case. Yes, sir.
let me ask you a question about preservation of error. I know there was an objection to the testimony about the mother or the defendant being manipulative and aggressive. But it's my understanding the judge's ruling was that he would permit the state to show some of those characteristics or personality characteristics that were testified to, I assume, by your expert. Well, does that require that during the subsequent rebuttal testimony by the state that you get up and say, look, that's not a characteristic or personality character that was testified to by our expert, and therefore I object? Or
Before the daughters took the stand that morning, I brought this up to the court, and I said, look, in the weekend, going over their testimony in the depot, Your Honor, I don't think they have anything to add. And I read excerpts of the girl's testimony where she said, I can only tell you about my mom's character. And I told the court that I was afraid that in response to what would sound like a valid question, that they would throw in this mud, and at that point a curative instruction would be, ineffective. And the court, and we went through some of the testimony that was in the depositions in the court, made a definitive ruling that no, Dr. Greer relied on what she said, in part, on his opinions, and therefore I'm going to allow the state to introduce character evidence to show that that's not her character or personality.
but there's character evidence that your expert had testified to. Is that correct?
I'm sorry, Your Honor?
But wasn't it just character evidence on characteristics that your expert had testified to?
Yes.
So do you need to make an objection again to say, Judge, that's something that the expert did not testify to?
Well, I think I tried to make that clear in the motion in limine before they, when the state said no, they put the character at issue, and I'm going to be able to rebut it. And I said, Judge, we did not put the character at issue. It's not an issue. If anything, it's going to be her credibility at issue, but not her character.
But you acknowledge that her character to commit violence would be something that the state could rebut?
Yes.
All right. So does the judge have to, what other characteristics that can come in? We've had aggressive, we've had manipulative, we've had, bad mother. Do you need to object at different points because the judge may find, aggressive, that can come in, but bad mother, that can't come in?
When the first testimony came out about aggressive and manipulative, I made yet another objection, Your Honor.
Right.
And it was overruled, and I made the decision at that point that this stuff is coming in. And as a trial attorney, I made a decision to say, if I stand up and object each and everything, it's just going to highlight this. And I tried to preserve the record the best I could without prejudicing my client who continually object to this information.
All right. Thank you.
Okay, thank you. Your time's exhausted.
Thank you, Your Honor.
Thank you, counsel.